My name is Gordon Zeiderweg. I'm a historian. I'm also an attorney, a practicing attorney. I also teach at a small university, Pacific States University, in Los Angeles. I teach various legal courses, including international law, and as part of international law, I teach about the civil law, Roman civil law. Now, the Roman Empire was vast. It stretched at one time from the Scottish border to Mesopotamia. Thomas Sowell, the American writer and social critic and political commentator, once wrote that the Roman Empire casts a long shadow even today. I'm here today to talk to you about one of those shadows, which is the Roman law, sometimes called the Roman civil law. Now, I'll caution you that the term the civil law or civil law has two meanings. One is the one I just used, which is the Roman civil law, the system of law derived from the legal tradition of the Roman Empire. The other use of the term civil law is to distinguish non-criminal from criminal law. But when I use the term in this talk, I'm going to be using it to denote the Roman civil law or civil law. Now, the Roman civil law is the basis for most of the legal systems of Western Europe and Latin America. It's the basis for the legal systems in Quebec and the state of Louisiana and Roman Catholic Church law. How did this happen? How did this come about? Well, as I mentioned to you, the Roman Empire was vast. At the head, at the apex of the Roman Empire was the emperor, or when the empire was divided into two halves, the Western and the Eastern empires, the emperors. Now, among the roles of the emperor was that the emperor was the ultimate source of justice. As such, he had two important functions. One was he oversaw the implementation of all law within the empire, whether it was Roman law or otherwise. Secondly, he was the supreme judge of the empire, because as emperor he had magisterial power, what the Romans called imperium proconsulare. In practical terms, the emperor and the various governors of the provinces spent much of their time administering the law. The emperor's court became the center for administration of the empire's judicial branch. In the empire, the governing legal principle was quod principi placuit leges vigorum, which meant an emperor's decision has the quality of a law. Roman law became a collection of imperial judgments by the emperor. From time to time, various Roman legal scholars or lawyers or judges would try to collect these judgments and organize them in a compilation of laws, but none was really very satisfactory. Then came along Theodosius II. He was the emperor of the eastern half of the Roman Empire, which was centered in Constantinople. He ruled from 408 to 450. He was a Christian. He did other things. He founded the University of Constantinople, but he also tried to organize the legal system. He ordered the formation of a commission to create a systematic corpus of the law. From 429 to 438, the commission examined the laws from Constantine on. In other words, from the first Christian emperor on. They came up with what became known as the Theodosian Code, or the Codex Theodosianus. The Codex Theodosianus, the Theodosian Code, was published in 438 in the eastern half of the empire. It was adopted 1 year later in the western half of the empire by the Emperor Valentinian III. As big an improvement as the Theodosian Code was, it still had its problems. And thus, in the 6th century, Justinian I decided to do something about it. Now, who was Justinian I? He was the greatest of the latter Roman emperors. He ruled once again in Constantinople, in the eastern half of the empire. He ruled from 527 to 565. The Eastern Empire, the eastern part of the empire, is sometimes called the Byzantine Empire. The western half of the empire had fallen in the previous century in 476, but Justinian I was an ambitious man. He reconquered parts of North Africa and Italy. Indeed, parts of Italy would remain in imperial hands until the 11th century. He also stopped the Persians in their incursions into the eastern part of the empire. The Persians had been aggressively invading and attacking the empire. Justinian I stopped them cold. He also decided to reform the legal system and improve upon what Theodosius had done. He established a commission to codify the Roman laws. This commission collected the laws that had been written down over the centuries, these imperial judgments. The aim was to make Roman law available to the judges throughout the empire in an understandable form, something that they could refer to. It would be readily available and understandable. Justinian and his commission published a whole series of legal works. In 529, they published the Code. 533, they published the Digest. In 534, they published a revised code. And lastly, they published the novels, which were concerned with the judgments of Justinian I himself. All of these works taken together became known as the Corpus Juris Civilis, or the civil law. The fortunes of the Byzantine Empire waned in the west, and soon the Justinian Code was lost to the west. But just a few hundred years later, it was reborn. A few centuries later, the foundation was established for the civil code, the civil law, to become the basis of many of the legal systems in Western Europe and in the Western Hemisphere. How that happened is the subject of the second part of this talk, which you will be seeing shortly.